Hi, Greg.
Hi there, can you hear me okay?
Yes, perfect.
Yeah. Sorry, I don't know what happened there.
No worries, no worries. How are you?
Yeah, I'm good, thank you. And you?
Great. Thanks.
How are you, Paul?
I'm good, thank you. Yeah, good.
Hospital go okay?
Sorry?
Did the hospital go okay?
Yes, but no, but. I've got an ear infection in both ears.
Okay.
And I've had it now for over 2 months, or almost 2 months. And
yeah.
it's still not disappeared. So
Right. That's
they're
frustrating.
not varying the treatment. They're just saying plug away with the treatment.
Okay.
It'll go eventually. So I'll go to Brazil on Sunday. And then go back again when I get back from Brazil.
Okay. What are you going to Brazil for?
I'm speaking in a DRBF conference.
Okay.
And then I'm going to take 4 days off afterwards and then come back. I'm
Nice.
going to go into the interior to the Iguazu Falls.
Okay.
Yeah, look at them. Look up.
Yeah.
They're the largest. I don't know what you have a range of mountains. I don't know what you have of waterfalls, but the largest range of waterfalls in the world apparently.
Okay.
They span Argentina, Brazil, and Paraguay.
Okay.
So nice hotel right on the waterfall. So I'm just going to chill.
Yeah.
No jungle trips or anything. Yeah. Or rain. There's jaguars apparently in the rainforest right behind the hotel.
Right. Okay.
Big signs up. Don't walk in there by yourself. And if you see one,
careful.
Do this and don't do that.
Yeah. Oh, that'd be interesting. Have you been before to Brazil?
Yeah. I spoke at the ICC FIDIC conference just before lockdown.
Sure.
The last trip before lockdown. So, but that was more or less an in and out.
Yeah. Okay.
But this one's a bit longer. I think I fly on Sunday and I land a week on Wednesday. It's quite a long flight.
Yeah.
I think it's 12 hours or 12 hours or so.
Where is there a direct flight from London?
Yeah.
Yeah. Okay.
Yeah, I fly with LATAM, the locals.
Okay.
It's half the price of British Airways.
Yeah. They're extortionate British Airways just now.
Yeah, they've got IT problems as well. They're cancelling flights left, right, and centre at the moment.
Oh yeah, yeah. One of my colleagues flew out here last week, and his flight got cancelled. Just a couple of hours beforehand.
Yeah, I mean,
yeah.
A long time ago, I had a flight delayed 36 hours because of IT problems.
Okay. Yeah.
And it was pandemonium. We flew empty, no luggage in the end. We had an option, either get up in the air and get to Canada. I was on holiday, get to Vancouver, or stay and wait for
the bags.
Flight. The bags had all got lost in that 36-hour delay, basically.
Yeah.
So
it's a shambles.
A shambles.
Everywhere else can do it properly, but BA can't for some reason.
But I did manage to, instead of just taking the £200 compensation or whatever, I bargained with British Airways and I managed to get up to 4 free tickets anywhere in the world.
Oh, great! Yeah.
On the basis that won't cost them anything.
Yeah.
So I got four tickets. So I now know how to get tickets out of British Airways. I don't like British Airways. I must admit, I avoid them if I can.
Yeah.
But where's Simon?
Yeah, I just sent an email across.
And then, Jatan, with this, is it? I think you said it's streamed to YouTube.
Yeah.
Is that how it works? So can the audience participate in this? Will they be joining the Zoom call or?
No? They will not be joining the Zoom call on YouTube. They can put in questions, and I will put them in the chat.
They would type their Oh, okay. So you would see the questions.
Yeah, yeah. And then I'll just
Understood.
pass them on the Zoom chat and
Yeah.
can
that makes
decide who wants to do what. Yeah.
Sure.
Yeah. Simon. I've just emailed Simon's practice managers to check with him. Sorry, Greg, you're on mute.
Sorry, yeah. Can you see, Jatan, how many people have joined on YouTube?
No, I can't yet. Once I go live, I think then I will be able to.
Ah, okay, it pops up.
Yeah,
Yeah.
yeah. Right. Good afternoon, good evening, everyone. My pleasure to welcome you on behalf of SCL-India to session 4 of our FIDIC series. The broad topic for this session is contractor claims. And to quote Simon, who doesn't love contractor claims? Suppose the answer is probably employers. But any case, the broad topics that we're going to deal with under contractor claims are timely ones: notices, entitlement, and how to prepare claims. To take us through these topics, we have with us Simon Hughes, who's a senior King's Counsel at Keating Chambers. His practice area of focus is international arbitration in the areas of construction, engineering, infrastructure, and energy. In addition to international arbitration, he also is involved in a number of investment treaty arbitrations where the investment dispute will often be a major national project. He has undertaken arbitrations all over the world, and to date, he has acted in a whopping number of disputes with applicable law of over 30 different countries. He was Legal 500's Construction and Energy Silk of the Year in 2019. He is the co-author of well-known books on the FIDIC Red and Yellow books, and he is the new senior editor of Keating on Construction Contracts, along with Piers Stansfield Casey. Then we have with us Greg Sibbald, who is a partner with CMS and is based in Dubai. He primarily acts for construction contractors and consultants in resolving disputes on projects across the Middle East, including the UAE, Oman, and Saudi Arabia. Interestingly, he represents a number of Indian headquartered contractors in arbitrations arising out of projects in these jurisdictions. He is recognized in the legal 500 EMEA as a leading individual in construction and has been based in the Middle East since 2016. Then we have Paul Battrick. Paul Battrick has graced us with his presence as a speaker in the first session of this series, and we are grateful to have him back. Paul is a chartered surveyor and managing director within the Driver Group. He has over 40 years of experience within the construction industry, and he has worked for clients from around the world and projects spanning the globe. In fact, he has acted for French, Portuguese, German, Italian, Spanish, Belgian, Dutch, Danish, Austrian, Japanese, and Korean clients on projects within Europe, the USA, Canada, the Caribbean, South America, Africa, the Far East, Australia, and the Middle East. That's pretty much the world, I suppose. Paul's work involves advising clients throughout the lifespan of a project, contract management, and up to the dispute stage. And he has also acted as expert witness, DAB member, and mediator. It is my pleasure to moderate our three speakers here today on the topic of contractor claims. My name is Jatan Rodrigues, and I'm an associate at Khaitan & Co. And yes, without further ado, we will start with Simon's presentation on notices. Do they matter? Yes.
Jatan, thanks very much indeed for that introduction. And I think this is going to be a very interesting session because Greg and Paul are very well known and very experienced in this particular space. And I happen to have worked with them and, for example, relatively recently with Paul on road jobs in Trinidad of all things. But the amount of experience that you've got in those two heads alone, leaving aside Jatan and myself, is substantial. So I think we've all got parts to play in this in terms of presentations. I'm going to go first, and then Greg, and then Paul. But there's going to be space for questions. I think we've got some questions that Jatan you've got, and we can have broader questions either during or between sessions, or indeed I think there's provision for them at the end. So please approach this very much as something where Paul, Greg and myself are very happy to deal with things as they come, as indeed one has to when one's acting for contractors. So without further ado, my little segment is on notices. Notices, do they matter? And if we could just go to the next slide, slide 2, and I probably ought to mention as well that the slides will be available, I would think, won't they, Jatan, to people who want them. But if Jatan, could you go, I think you're going to be driving, so could you go to slide 2 if possible? Brilliant. So slide 2, which would be back one slide, is in effect notices. What do we mean? Jatan, would be any possibility that we could go to the slide with the number 2 at bottom right hand corner? Brilliant. So notices, what do we mean? Well, a paradigm example of a notice would be, and I've plucked this out, obviously lots of different contractual terms, main contract terms, subcontract terms, and so forth, have slightly different provisions. One always has to be very careful about exactly what the provisions say. But a very good typical example of what we mean when we talk about contractual notices, which may operate against a contractor, would be subclause 20.1 of the 1999 FIDIC Red Book, the remeasurement form within the FIDIC suite. And the words are on the screen there, but essentially if the contractor considers himself to be entitled to any extension of time for completion or any additional payment under any clause of these conditions, or otherwise in connection with the contract, the contractor shall give notice to the engineer describing the event or circumstance giving rise to the claim. And then the important words in one sense, the notice shall be given as soon as practicable and not later than 28 days after the contractor became aware or should have become aware of the event or circumstance. And then also very important, the final words in this particular part of subclause 20.1, which are the potentially fatal part, which is the stipulation as to what happens if a notice is not given. Contractor will not be entitled to additional payment, time for completion will not be extended, and the employer shall be discharged from all liability in connection with the claim. Now, I'm going to go through some of the components of that language because it's quite an involved clause in a few moments' time. But in broad strokes, that's the sort of thing we are talking about when we're talking about a contractor's requirement to give notice. They must give notice of claims in a particular format within a particular time frame, and oftentimes, if they don't, there will be a stipulation that certain consequences will follow, and often those consequences will include the loss of entitlement. Often, but not always, it will depend on the clause. And Jatan, if we could go to slide 3 very briefly. What I just wanted to talk to you all about very briefly is, well, what's the commercial rationale of these provisions? Because judges and arbitrators will not generally favour contractual provisions which simply exist to punish a contracting party. They will often want to understand the commercial justification for the provisions. And the justifications are, in a sense, fairly clear to see. If there are provisions whereby a subcontractor to a contractor or a contractor to an employer has to notify any claims that they wish to make under the contract or otherwise within a certain time frame, then that enables the contract to be administered and managed. And often these contracts will run for a year, 2 years, potentially 5 years, and they could have an operation and maintain element, so they could run for 10, 15 or longer. So there is a legitimate interest in stakeholders, maybe the banks, financiers, the employer, the clients, those in the contractual chain, in all understanding what are the claims. And again, reporting to stakeholders. If there are stakeholders, whether they be investors or banks or potentially government, that they're all entitled to know, well, what is the downside risk of this particular project? And that will include the risk of claims which take the expense of the project over and above the bid contract sum, for example. And then the third often given justification for notice provisions is, well, if in month 5 of a 24-month contract, I, as the client, the employer, am told that there are delays and that there are going to be claims for delay, then that opens up the possibility that the employer can introduce mitigation measures. That might mean resequencing the work. It might mean instructing additional resources to mitigate matters. But there are all sorts of commercial purposes that can be served in a way by the service and provision of timeous notices. Jatan, if we could go please to slide 4 very briefly. I just want to essentially anchor what I've just said in the in a couple of, well, in one particular case. Now, this is an English case. It's part of a judgment of Mr. Justice Rupert Jackson, as he then was. He's a very well-known, very experienced Court of Appeal judge in England more recently than this decision. But this is of broader applicability. This isn't a narrow colloquial English point. It's really identifying, in this case, some of the commercial purposes that notices have. And that's important because what one can see from this judgment and from other judgments in other jurisdictions and arbitral decisions is that there is, by and large, respect given to notice provisions. They are seen as having a legitimate purpose, and that's important because they will generally be enforced. On questions of enforcement, what we need to then look at, and perhaps we go to slide 5, is the different ways in which different jurisdictions, different tribunals, different cultural setups will approach the interpretation of notice provisions. And what I've put on this particular slide to give you all a bit of a flavour of the variety of approaches that one can experience in different parts of the world, in different sort of industrialized economies and so forth. There is a variety, and it's worth noticing that the same words, FIDIC, subclause 20.1, for example, could be approached in somewhat different ways by different tribunals applying different governing laws. And one has to be aware of that, I think. So first bullet point here, I've called it plain and ordinary meaning of the language. And I've mentioned there a case of CMA and John Holland, which is Western Australia Supreme Court. Now, the courts of Western Australia happen to be distinguished in a variety of different ways, but one of the ways in which they distinguish themselves is they are particularly rigid and literal on notices, that they will enforce notices quite strictly in accordance with the plain and ordinary meaning of the language. And CMA and John Holland is a pretty good example of that approach. And that's an approach that one sees in quite a lot of common law jurisdictions. I would say, as a matter of nuance, that probably the courts of Western Australia and the courts in Australia generally are a little bit more harsh than, let us say, the courts in England and Wales. But that's a very fine distinction. But both jurisdictions would look at the plain and ordinary meaning of the language and seek to give effect to the words that are on the page. A second approach is what I've called the clear words doctrine. That is very clearly seen in an old case. It's an old House of Lords case called Bremer, Handel, Gesellschaft and Vanden. And what was clear from that House of Lords case is the whole court agreed, and I think the main judgment was given by the Lord Salmon, that the whole court agreed that if notice requirements are to have a debarring effect, in other words, if you don't serve a notice, you lose your rights, then the contractual provision has to be very, very clear about the consequences of not serving a notice. And another, not on notices, but very similar kind of thinking in terms of clear words is a very old but well-known English House of Lords decision, Gilbert, Ash and Modern Engineering. That was a case where the House of Lords decided that if a party was going to give up a common law general right, such as a right of set-off, I think it was in that case, then the contractual language had to be very clear to signal that that ordinary right had been given up. And so it is on notices that some tribunals will want and look for very clear language that the failure to give a notice has a debarring or preclusionary effect. And we saw that language, I think, in the words we looked at in subclause 20.1. lots of contracts are not quite so clear. For instance, there's JCT contracts predominantly used in the UK. They're quite a good example because they and other contracts with them might say a notice shall be given, but it doesn't explicitly say what the consequences will be if you don't. And in such a case, it would be open to the contractor to argue that the debarring consequences are not clearly spelt out, and therefore they don't have that, the words a non-compliance doesn't have that effect. The third approach, which I think is very interesting, I call it the purposive approach. And a very good example is Article 33 of the UAE, United Arab Emirates Civil Code. So UAE, as I'm sure you all know, that is Dubai, Abu Dhabi, and the associated Emirates. But the principle is a broader one in Article 33 of jurisprudence across a number of GCC jurisdictions. And Article 33 provides that a rule shall depend on its cause for existence and shall cease if the cause ceases to exist. Now, what does that mean? Well, in context of notices, and I've argued this, and I've seen it argued, and I've seen it successfully applied predominantly in arbitrations governed by UAE law. One starts with the position that the purpose, let us say, of a notice is to enable the employer to understand and know that there are claims coming, take steps potentially. And the way in which the jurisprudence would work is that, of course, that purpose is achieved by the service of a fully compliant notice. But that purpose could also be equally achieved by monthly progress reports, discussions, or indeed the independent investigations of the engineer or the client, where they're understanding the project, they know there are claims through a variety of different routes. Potentially they deal with those claims, that they're able to examine them, make offers in respect of them, and so forth. So there is a school of thought which would say, well, even if there isn't a copper-bottomed notice in accordance, let us say, with the strict terms of subclause 20.1, if the purpose or the presumed purpose of notices is otherwise fulfilled in another way, then there's no problem. And essentially, the contractor should not be debarred because a rule shall depend on its cause for its existence, and the rule ceases if the cause ceases to exist. Bear in mind, that is a rendering into English of the Arabic, but one can understand, I'd hope, the overall purposive idea there. Final point, which is a sort of mix of the first two, in a way, and finds expression in a very well-known decision of Sir Robert Aikenhead, as he now is, a former very well-known TCC judge in London. The case is Abraskan and the Attorney General for Gibraltar. And what the judge said in that particular case is that, yes, subclause 20.1 notices, and the context was, I think, a yellow book, subclause 20.1 notices will indeed be given effect to and will be enforced. But then he went on, I see no reason why this clause should be construed strictly against the contractor, and can see why it should be construed reasonably broad, given its serious effect on what could otherwise be good claims, for instance, for breach of contract by the employer. So in other words, what that will potentially lead to is a position where, sure, notices are required, but if they are not an exact articulation of a claim, if they don't reference contract clauses, if they're a bit thin, one can understand perhaps how judges and tribunals will look through those inadequacies and say, well, we're going to construe this particular alleged notice reasonably broadly, because the consequences of it not being a notice at all would be so serious. Those are essentially a set of bullet points designed to illustrate that this is not a one-size-fits-all exercise, and it's not even a one-size-fits-all exercise in the context of something like FIDIC subclause 20.1. There are nuances, there are differences in approach, and those will be driven by what I might call cultural approaches in terms of your tribunal, and most certainly driven by the precepts and norms within the governing law, whatever that governing law may be. So if we could go then to slide 6, please. And what we can see here is that beyond the provisions of subclause 20.1 that I took you to at the start, that there is then a reference, which I think Paul's going to pick up on in more detail. Once a notice is given, the contractor shall keep contemporary records as may be necessary to substantiate any claim. So one has to understand that a clause like subclause 20.1 has a number of components. First of all, you've got the notice, and I will come back in a moment to the language of the first part of subclause 20.1. But secondly, you've then got the shall keep contemporaneous records to substantiate the claim. And then thirdly, if we just go to the next slide, slide 7, please, Jatan. Within 42 days after the contractor became aware or should have become aware of the event or circumstance, and I'm not going to read the rest, except the contractor shall send to the engineer a fully detailed claim. So what FIDIC envisages is you've got a notice, let's supposing it's just a single claim, and obviously life is a lot more complicated than that, but let's supposing there is a single claim, a single event where it is thought that the event has or will give rise to an entitlement to an extension of time under subclause 8.4. So you've got to have a notice, you've then got to keep records, and then you've got to provide a fully detailed claim. I see those three elements as very much inextricably linked. And it's not the case that you serve a notice and you're done. You have to bear in mind that ultimately the service of a notice gets your foot in the door, but then you're going to have to prove your claim with documents, and Paul will deal with that in more detail. But then your notice is not really a fully detailed claim. It might be a page, it might be 2 pages, your notice. A fully detailed claim will develop your causes of action, the facts on which you rely, the time that you seek, extension of time, and any money, cost, or profit that you seek. Jatan, if we could possibly just go back to slide 2, I just want to touch very briefly on the initial language of subclause 20.1. So it would be slide number 2, just to pick up the opening words really of subclause 20.1, and just really to highlight a few points if we could. I wonder whether we could just have that briefly on screen. What I'll do is I'll just speak to it. Now, I'm sure the slide will come up on screen momentarily, and it's going to be slide number 2. So it begins, slide number 2 begins, if the contractor considers himself entitled to an extension of time. That's quite important because if, for example, I consider that it's going to rain tomorrow, that use of the word consider suggests something which is entirely subjective. In other words, I might be right, I might be wrong, but it's what I consider to be the position. That's not generally how this clause is construed. It considers, and the contractor considering themselves to be entitled to an extension of time, that is usually regarded as having a sort of subjective element. In other words, the contractor has got to have an awareness, an actual awareness that they have this potential entitlement, but also there is an objective element, which is that they've got to act, the contractor has to act reasonably and responsibly. Jatan, I don't know whether it's possible to go to slide 2, but if we could just, so that's the first thing, if the contractor considers. What I would then just pick up on is what is the scope of subclause 20.1? Well, it covers extension of time for completion, and or any additional payment under any clause of these conditions, and then these words, or otherwise in connection with the contract. So just pausing there, the view that I would take is that subclause 20.1 is engaged where the contractor has a claim under any provisions of the contract, but also where there is a claim at law. For example, for breach of contract, or a claim in restitution, potentially. If there's a claim at all, I would say that subclause 20.1 and the language that is used is all-encompassing. And of course, that makes complete sense because it would be slightly odd if the contractor had to give notice of claims under the contract, but all other claims it could keep up its sleeve and deliver to the employer 2 years later. So the words or otherwise in connection with the contract almost certainly cover all manner of claims that a contractor is likely to be concerned with. And then the contractor shall give notice. So that is the mandatory, obligatory part. In other words, if you want money or time, then you're obliged to give notice. And just pausing there, the giving of notice, that there is no prescribed format in this clause for how notice shall be given, but what you would always want to do is look at the rest of your contract. And I think subclause 1.2 or 1.3 deals with, in the FIDIC standard form, deals with what I think is titled communications, so that there is a stipulation elsewhere in the contract, in the standard form at least, as to how communications should be given. And in any contract, you would always want to be very clear and careful. If there is a shall give notice provision, then one has to be very careful to deal with and essentially abide by the communications protocols that are given. So, for example, that means often communications have to be in writing. They may have to be given by a certain contractual person, nominated by the contractor, for instance, to somebody within the engineer, somebody within the employer. So shall give notice. One has to pay attention to that. And then we have describing the event or circumstance, giving rise to the claim. What do you have to do there? Well, you have to, in what I would say, is you have to do enough to indicate that you are making a claim. Paul is going to talk about the concept of a claim, but for example, if you write to a client, an employer, as a contractor, and you say the piling is 3 weeks late due to problems with the ground, and you simply report that fact, or if you say the formwork is late because the designs are late, I think you run the risk that that is not the giving of a notice of an event or circumstance giving rise to the claim, or a claim notice. It might be, but you run the risk of it being said against you as a contractor that you've described an event, you've potentially made a complaint, but what you've not done is made a claim, in the sense that you have not formulated the fact that you are seeking a remedy, whether it be an extension of time or an additional payment or something else. And so when you're giving notice under, for example, subclause 20.1, what you have to have in mind, in my sort of view of things, probably a little bit simplistic, but the way I would see it is clause 20.1 is all about, if you don't ask, you don't get. And the way you ask is you serve a notice. And on the basis of the principle, if you don't ask, you don't get, you've got to say what you want. So you've got to ask for something, and that will be generally something has happened, and not a so what, but, and therefore we want an extension of time, or we want money, and so forth. Is it necessary to cite all of the contractual provisions in your notice? Well, I think it is useful and prudent if you can, but of course there might be all sorts of contractual ways you might want to describe the claim. So one can understand why you might not want to be exhaustive or lay yourself open to not having cited all the clauses. I would say it is prudent to reference contractual clauses. Is it essential? I don't think it is essential. And one bears in mind the views expressed by the judge in Nebraska, which is that a notice should, once given, be given quite broad, a broad interpretation. Just very quickly on this provision, final sentence, first paragraph, notice should be given as soon as practicable, not later than 28 days. And then this, after the contractor became aware or should have become aware. Now, we talked about this subjective objective element by reference to the word, the fourth word in this clause, considers. And I think the fact that there is a subjective and objective element here, it is reinforced by the words became aware or should have become aware. Because of course, a contractor can't seriously put their heads in the sand or be completely hopeless, rely on their own head positioned in the sand or hopelessness, and not serve a notice for 2 years because they weren't actually subjectively aware of the possibility of a claim or an entitlement. So there is an objective element here, and one has to bear that in mind. In other words, an arbitral tribunal or a court is going to look at your notice and the time of its delivery and ask him or herself, well, look, when was this notice served? When should the contractor have become aware of the event or circumstance that they're relying on for their claim? We've talked about the final words already. I think the final 3 lines of this clause are absolutely critical, and they comply with the Bremer Handelsgesellschaft and Vanden principle, which is if a clause is to have a draconian effect, then you expect some words in the contract saying exactly that. So very, very briefly, in the time I've got left, I'm going to be pretty quick about this because essentially Paul and Greg will pick up on a number of these points. Slide 8, very quickly, Jatan, if you wouldn't mind. There are different considerations that you might want to bear in mind as a contractor or a person advising a contractor, depending on the type of claim you're talking about. I'm not going to get into types of claim in any great detail, but very quickly, if we go to slide 9 and just on extensions of time, it's important to bear in mind that subclause 8.4 talks about if completion is or will be delayed by any of the following causes, and then you've got variations and all of those provisions, which I think Greg is going to run through. But what is very clear is that the contractor has a little bit of leeway here. They can claim essentially at their election on the basis that prospectively looking into the future, maybe with a time impact analysis type approach, they can see that the works will be delayed. So they can give notice at that point ahead of time, or, and bear in mind, this might help the contractor quite a lot, they can wait until the works have actually been delayed and the delays actually hit the critical path, for instance, and then give notice. And what's interesting in the Abrascon case, which I mentioned in the bullet point at the bottom, is that the judge, Sir Robert Aikenhead, in that particular case, noted that subclause 8.4 and read together with subclause 20.1 doesn't talk about is or will be delayed, whichever is the earliest in time. So it's up to the contractor. And so the contractor can effectively see a delay potentially on the horizon with forward-looking prospective analysis, but can potentially wait until that that delay actually hits the critical path. Now, that is something that the contractor is going to have to make a judgment on. I would have thought if you've got forward-looking analysis software and you're doing time impact on your project and something comes on the radar as likely to impact matters. So, for example, supposing it is off-site procurement of complex machinery and the order is late or it's been messed up, and one can foresee a circumstance in which the delay to off-site procurement is potentially going to impact on-site works, I would have thought out of prudence, notwithstanding the references in Abrascon that I have on screen, I would have thought out of prudence one would give a notice so that you're covered, because that procurement issue may or may not impact on-site works, but you're covered. So I would have thought less rather than more rather than less in terms of notices in that particular circumstance. If we then go over, I'm going to deal with this very quickly, slide 10, variations. But bear in mind, you've obviously, in most contracts, you're going to have a variation procedure. So clause 13 in the FIDIC 1999 edition. It's often argued, I've seen it argued generally unsuccessfully, I've seen it argued that, well, if the contractor has complied with one regime, then it doesn't need to comply with the other regime. It will depend very much on your contract. Watch out for contractual provisions like variation provisions, and we'll come on to force majeure in 30 seconds or so. Watch out for contractual provisions that say subject to subclause 20 or subclause 20.1, and then you can make a claim for a variation, force majeure, or whatever. Those words subject to subclause 20.1 are a bit of a telltale sign, a bit of a red flag that you need to do whatever the contractual provision giving you the entitlement says you have to do, and also comply with subclause 20.1. I'll say no more about that because I think that's going to be picked up later. But slide 11, force majeure. What's very important with FM claims, force majeure claims, And I'm giving you an example here from subclause, clause 19. With FM claims, you obviously have to give a notice in respect of the FM event. In other words, a force majeure event within the description, for example, of subclause 19.1, it would be, has occurred, etc., etc. So you've got to give that notice. But then you've got to give a separate notice, and this is very important, identifying the consequences of any FM event. And what you will also notice within subclause 19.2 is that that provision is expressly subject to subclause 20.1, at the point I was just on a few moments ago. In other words, you have to be very careful with things like force majeure, that you comply with the very particular notice provisions within the clause, but then you also ask yourself the question, do I also need to bring myself within subclause 20.1? Next slide, briefly. Touched on this already in many respects. I take the view that subclause 20.1 is of the broadest possible kind, so that it covers claims under the contract and claims for breach of contract, and any claims that you think you might have under the governing law generally, so under a civil code or common law restitutionary claims or whatever. Slide 13. So what happens if you fall short? You come to make your claim, you're good on the facts, you've got some merits, the claims are good, but then somebody comes and tells you, well, actually, we might have a bit of a problem because we haven't served any notices, or the notices are a bit rubbish, or they're rather late. Well, it will depend on your governing law. It will depend on your tribunal. And so you always have to think of those things very early on. What's your tribunal? What's the governing law? What facts have you got? What documents have you got? First of all, you're going to want to try and run the purposive approach, which we talked about a little bit earlier on. In other words, notwithstanding the absence of a full-fledged notice, has the essential purpose of the notices been fulfilled? There might, under certain governing laws, for example, French Civil Code, UAE Civil Code, and so forth, there might be principles of good faith that may help you. In other words, the parties have so conducted themselves that it would be bad faith dealing for the employer to seek to deny your claim on grounds of lack of notice. Under the common law, very similar sort of analysis, estoppel and waiver. I've seen those work, and I've run those arguments quite successfully, where, for example, the engineer has dealt with claims and paid money on account, or has certified sums formally, so not on account, but has certified sums in respect of claims. It is very hard if the engineer, essentially acting for the employer, has certified and dealt with sums and then turns around and says there's no entitlement because there's no notices. That's quite tricky for an employer. Sometimes, final bullet point, there is an argument that, well, regardless of the absence of notices, there is a freestanding obligation on the employer to assess claims. I've never been very persuaded of that argument, I must say, because oftentimes one sees when it becomes very contractual and slightly aggressive, the engineer will sit on his hands and say, I'm not assessing anything because there are no notices. And it's very hard in practice to get the engineer to budge from that position. And the engineer is going to be very careful, given the waiver and estoppel type arguments that mill around, as just discussed. The engineer is going to be very careful by dealing with claims and engaging with them. The engineer might potentially walk into a waiver for which he's then criticised by his client. So that's very difficult. But final slide, essentially. I always think the facts are the most important. If you're seeking to deal with a problem that you may have in your case on notices, start with the facts. You've always got legal arguments, potentially, but generally speaking, if you've got a decent factual case, the legal analysis should take care of itself, or the legal analysis should follow. But the facts are going to be crucial. Now, if you've got a notice problem, it's the easiest thing in the world to run around, look at textbooks. What could you do? I don't think that's the right place to start. The right place to start is the documents, the facts, the witnesses, what's actually happened. And so, for example, you can find, if you rummage around in the facts, if you do your homework, you might find that the employer at a meeting said early on, please stop issuing notices. That's going to be very helpful to you, because if the employer said that, then principles of good faith, potentially principles of estoppel and waiver, may make it very difficult for the employer to rely on notices. Again, if the employer's made part payments or certified sums, despite the absence of notice, that might be very helpful to you. Of course, you have to look very carefully about the payments, because oftentimes what you may find is that an employer or an engineer will say, well, we're paying these sums on account to keep you, the contractor, as it were, alive. Nice of them. But that is entirely without prejudice to all of our rights and remedies under the contract. And of course, we reserve the right to pull this money back if you can't prove your entitlement. So part payments alone might not be enough, because there might be weasel words, there might be language which mean that they are still able to run their notice points. So you have to be very careful about that. And finally, if the engineer has in fact and in substance assessed claims, then again, that may mean that the notices arguments are very difficult for the employer to rely on. It's all going to be on the facts. It is the point that I would emphasize here. Now, I've probably outstayed my welcome. I hope that was very useful. Thank you very much for listening. And I think we're going to take a short break, as I gather, and then it will be Greg on the subject of different types of contractual claims that can be made by a contractor. So thank you very much. Jatan, back over to you.
Yes, thanks, Simon, very much. And yes, that was a very insightful presentation, very important sub-theme. And yes, as you said, we break for 10 minutes and we see all of you back at 7:40 India time. Hello, everyone, and welcome back. Next, we have with us Greg, who's going to present on entitlements to cost and time, and he's going to walk us through the various provisions of FIDIC contracts generally that could trigger these entitlements. Right, Greg, over to you.
Great, thank you, Jatan, and thanks everyone. And I guess also thank you to Simon for your presentation there. I'm just going to share my screen, so just bear with me. Okay, can you see my slides okay? Can everyone see my slides?
No.
No, okay. What can you see?
We can see your screen.
Just my screen, bear with me. 2 seconds. Can you see them now?
Yeah, they're
Yes.
on now, Greg. They're
Great,
perfect.
Great, thanks everyone. Okay, I guess, so yeah, as Jatan mentioned, today I'm going to talk about contractors' entitlement. And I guess just as a sort of segue into that and following on from Simon's discussion, what we often find is when we have clients, contractors coming to us, they've maybe had an issue with a notice, for example, or notices, they haven't served them on time and they're looking for arguments to try and overcome the notice issue and pursue their claims. It's quite often the case that there's plenty of sort of legal arguments or contractual arguments that can be used, but where there is a strong underlying claim, so which has been pled correctly with reference to the contract, properly substantiated, it can be quite rare for a employer, once you get to sort of final account stage, or at least kind of moving towards where things look like they could be going towards arbitration, to simply defend their claim or defend the claims on the basis of notices alone. So I guess the sort of point there is that even in circumstances where you're facing perhaps challenging notice issues, if you have an underlying strong claim, properly pled entitlement and costs, then you really shouldn't sort of give up on the basis that the employer is probably unlikely to defend an arbitration on the sort of notices issues alone. So I guess sort of with that kind of background setting, there's obviously sort of various types of contract claims that can be advanced under the FIDIC model. So there's claims for payment, such as failures to pay certified sums, late payment, or under certification. Variation claims, such as claims for additional payment and changes to work scope, and time-related claims, such as extensions of time, prolongation costs, disruption costs, and acceleration costs. Today I'm going to focus primarily on time and prolongation costs, mainly because these are probably one of the most common types of contractors' claims. However, a number of the sort of principles and tips that I suggest can be used across other types of claims. And similar to Simon, I'm focusing primarily on the 1999 suite of FIDIC contracts, sort of red, yellow, and silver books. So I guess extension of time claims. So the relevant clause, which allows the contractor to claim an extension of time in the 1999 suite is clause 8.4, and that was obviously referred to by Simon. It's there to allow a contractor to point out where he has been delayed by reasons beyond his control. If he cannot do this, he will be liable for liquidated damages for delay. So the sole purpose, obviously, of an EOT provision is to overcome a claim for liquidated damages. As a general point, if the contractor obtains an extension of time, he may be in a position to recover his time-related costs for remaining on site longer. However, there is no natural link between clause 8.4 and money. It's a time clause. A common misconception is that an EOT award equals money. However, that's not the case. Any claim to time-related costs has to have its own and separate underlying basis. So I'll talk a bit about costs later and a contractor's right to recover them, but I'll start just now with dealing with EOT claims. So as mentioned, an EOT entitlement arises from clause 8.4. As a general point, another misconception amongst contractors is that it's right to claim an EOT and costs arises from 20.1, which Simon was obviously discussing. That's not correct. This deals with the claim process and the procedure, and it's not a basis to claim EOT. The basis is in clause 8.4. So in terms of 8.4, the starting point is that the contractor is obligated to complete the works in any section within the time for completion for the works or section. This is an express obligation on the contractor. Subject to the terms of 20.1, subclause 8.4 is clear. The contractor is only entitled to an extension of the time for completion if and to the extent that completion is or will be delayed by any of the following reasons. Sorry, I've jumped a slide. Sorry, yeah, so there's 8.4 there. So any of the following reasons, and they're obviously set out within clause 8.4, and those include a variation, a cause of delay given an entitlement to an extension of time under a subclause of the contract conditions, exceptionally adverse climatic conditions, unforeseeable shortages in the availability of personnel or goods caused by epidemic or government actions, and any delay, impediment, or prevention caused by or attributable to the employer. So let's break each of these down. So variations. Variations are dealt with in clause 13 and generally include changes to the quantity, quality, levels, dimensions, or any parts of the works. Omissions to the works unless it's been carried out by others. Any additional work, plant materials, or services necessary, and changes to sequences and timing. It's our experience that it's often the case that variations are the main cause of delay on projects. So it's obviously an important provision. So and when a variation arises on a project, it's important to consider any time-related consequences and whether an EOT should be applied for. In terms of other subclauses, so obviously the FIDIC model has various express provisions throughout it, which sets out a basis to claim an extension of time in particular circumstances. So you'll see the table on the screen, which lists these along with the corresponding book which they relate to. But I guess just to go through sort of each of them in a bit more detail. So 1.9, a delayed drawing or instruction. So if the engineer fails to issue the requested drawing or instruction within a reasonable time, the contractor is allowed to submit this contractual claim and would be entitled to an EOT. 1.9, this just applies to the yellow book, errors in the employer's requirements. So if any error in the employer's requirements is found by the contractor which would not have been discoverable as an experienced contractor, the contractor has a right to claim. 1.13, compliance with laws, which is covered in the red, yellow, and it's in 1.12 of the silver book. If the employer delays or fails to obtain any permit, permission, license, or approval for the works, then the contractor should be entitled to an EOT. 2.1, right of access to the site. So if the employer fails to provide the contractor right of access to site within the time specified under the contract, the contractor is allowed to claim. 4.7, setting out. The employer shall provide the contractor with setting out information. If the contractor identifies an error in the setting out data which would not have been discoverable as an experienced contractor, the contractor has a right to claim. 4.12, unforeseeable physical conditions. Now this is often one that comes up as an issue in dispute on projects. So if the contractor encounters physical conditions which are unforeseeable, as an experienced contractor, the contractor can claim, and obviously the key point here is determining what is unforeseeable. 4.23, fossils. The contractor has the right to claim as a consequence of the engineer's instruction to deal with an encountered archaeological and geological finding. And 7.4, testing. The contractor is allowed to claim if the engineer is responsible for a delay in testing. 8.5, delays caused by authorities, where the delay has been caused by an authority which is unforeseeable. 8.9, consequences of employer suspension. The contractor can claim if the engineer provides an instruction to the contractor to suspend or resume the works pursuant to subclause 8.8. 10.3, interference with testing completion. If the employer and or the employer's personnel prevented the contractor from carrying out the testing completion, the contractor has the right to claim. 13.7, adjustments and changes in legislation. The contractor can claim as a result of changes in the laws of the country. This is obviously a provision that a lot of contractors relied upon when claiming EOT entitlements during COVID, given that a number of COVID claims didn't arise simply because of COVID occurring. It was more in the context of a law being introduced or a number of laws or provisions being introduced, which meant that there were certain restrictions impacting construction work, such as labour, for example, not being able to attend site, or certain health and safety precautions being imposed on sites. 16.1, suspension by a contractor. An EOT can be claimed where, as a result of material breach of the employer's obligations under the contract, the contractor suspends the works, such as a failure to pay an amount certified, then the contractor can claim. Termination, that also gives rise to, if the employer does not remedy matters stated in the subclause within the prescribed time, then the contractor may terminate the contract by giving a second notice and claim. 17.4, delay as a result of an employer's risk events, and those are fairly detailed, although in most instances you'll probably find that they have been deleted or removed from the contract, but those can include circumstances such as war or hostilities, terrorism, riot, or operations of force majeure. And then 19.4 goes on to deal with force majeure specifically, and deals with, again, issues of war, rebellion, riot, munitions of war, catastrophes, earthquakes, and anything that falls within the definition of force majeure within that provision. It's obviously quite a detailed and comprehensive list, but obviously the key point is that if the event causing delay has arisen from one of these scenarios, there is a express right within the contract to claim an EOT arising out of those. So in 18.4 also sets out that an EOT can be claimed for exceptionally adverse climatic conditions. So what does this mean? And the question arises, when is weather exceptionally adverse? The 1999 contract is sort of fairly limited in terms of its description of an exceptionally adverse event. However, the FIDIC 2017 provisions have provided a bit more detail. It describes those as climatic conditions on site which are unforeseeable, having regard to climatic data made available by the employer and or published in the country for the geographical location of the site. So in practice, it's likely that the literal meaning of the words exceptional and adverse will be applied. Whether that is considered exceptional will first have to be measured against the sort of weather that's usually experienced in the particular location at that time of year. And the question asked, was this weather expected or foreseeable? So I guess a kind of obvious example would be snow is unlikely to occur in the middle of the summer in Dubai, but sandstorms could do. So obviously the issue of what is exceptional will vary from country to country. Once it is established that the weather is exceptional, it was exceptional, the question then has to be asked whether it was adverse. This will require the contractor to demonstrate that the weather was the direct cause of the delay to completion, or that it triggers some other provision entitling the contractor to monetary compensation. There's also another route to an EOT in circumstances where it's been caused by weather, as I sort of mentioned earlier in terms of clause 19 and force majeure events, given that that covers hurricanes and typhoons. So 8.4 also sets out that an EOT can be claimed in where there is unforeseeable shortages in the availability of personnel or goods caused by epidemic or governmental actions. So I guess in the context of COVID-19, contractors whose supply chains were impacted by the pandemic could seek to claim time relief under this provision. However, such provision may not be applicable for contracts entered into post the COVID-19 outbreak, as these shortages were unlikely to have been unforeseeable. And in 8.4 also sets out that expressly that an EOT entitlement arises where there is a delay, impediment, or prevention caused by or attributable to the employer. And in these circumstances, there generally should be a clear breach of a provision of the contract by the employer that caused the delay. And a distinction in those circumstances should also be drawn between, for example, circumstances where it's really just some kind of, I guess the point is that circumstances should be drawn between where there's a clear breach or it's just in the ordinary course of the project, issues arise, which may be viewed as an impediment, but they're the sort of normal issues that arise on a project, which don't actually reach the sort of standard of being a breach. Those are unlikely to give rise to an EOT. In terms of costs, so as mentioned earlier, an EOT does not provide an automatic right to claim costs. Instead, a claim for costs will arise under an express provision of the contract as a claim for damages arising out of a breach of the contract or at law. And dealing with each of these in turn. So similar to the express provisions in the FIDIC that give rise to an EOT claim, there are a number of provisions that give rise to a claim for additional costs where a contractor has been delayed. In some instances, FIDIC permits costs only to be recovered. In other instances, cost plus profit can be claimed. In very general terms, profit is not recoverable for events where the employer is to blame, whereas profit normally can be recovered where the employer is to blame. So a common example of where costs can be claimed in 13 points, costs only can be claimed is 13.7 regarding adjustment for changes in legislation. And obviously, sort of mentioned that previously in terms of an EOT claim. So that circumstances where the law has changed, it's delayed the project, and it's also caused the contractor to incur additional costs. In those circumstances, only costs can be claimed, but not costs and profit, because it would be seen as unfair on the employer for them also to be held liable for profit in circumstances where it can't be held to blame for the change in legislation. A common example where cost and profit can be claimed is 2.1, the right of access to the site. So for example, if the employer fails to provide the contractor right of access to the site within the time specified, the employer can claim for any additional time-related costs that is incurred as a result of that. And here you'll see on the slide, these are the various provisions in the 1999 suite setting out where an EOT can be claimed, an EOT in cost, and an EOT cost and profit. And also, here's a similar table for the 2017 suite, and you'll see the provisions are sort of much more extensive within the 2017 suite. So other circumstances when costs can be claimed is where they arise through a breach of contract. So where an EOT arises from an event that would constitute a breach of contract, a remedy of associated prolongation clause lies in an entitlement to the damages arising from the breach. The assessment of such damages would be left to the court or tribunal, which would have a fairly wide discretion to determine the compensation of such damages. In consequence, and subject to the burden of proof being satisfied, time-related costs are, in principle, recoverable as a component of a damages claim. There does not, however, have to be a natural link between causation of the loss sustained. And I think Paul's going to go into a bit more detail in terms of what actual losses or damages can be claimed. The contractor should establish a specific provision within the contract which the employer has breached in order to demonstrate its damages claim. This could be something, for example, in the technical requirements or specification. An example would be, for instance, where maybe the employer has a duty to provide power and water for commissioning, but fails to do so, causing delay and additional costs to the contractor. Then in those circumstances, those additional costs can be claimed for a breach of contract. And then finally at law, this will obviously vary depending on the jurisdiction. But sort of in general terms, there's no statutory right or express statutory right to claim prolongation in most common law jurisdictions. However, there are provisions of the civil codes of certain civil law jurisdictions, particularly across the GCC countries, that arguably gives rise to a claim for prolongation. So yeah, a bit short and sweet, but any questions?
Yeah, many thanks, Greg. I think that was a very interesting presentation. I suppose the one question that I had, and this is an issue that comes up quite frequently in India. I've personally dealt with this, and most Indian contractors, lawyers, construction lawyers would be keen to hear your views. Is oftentimes when a contractor claims time, employers will ask them to provide what is called a no due certificate, essentially, that they will not claim cost as well. And conditional to that, the employer will then give them an extension of time. And how would you deal with situations like this when the employer says that I will give you an EOT, but sign off that you will not claim costs?
Yeah, no, thank you for that question. Yeah, that's a scenario that we experience quite often. So where a contractor has applied for an EOT, and employers came back and said, yeah, okay, we'll give you your EOT, but you've got to waive your right to claim costs. Generally, in those circumstances, it would obviously depend, firstly, whether the contractor believes they do have an underlying right to claim costs and the sort of strengths of that claim. But in circumstances where they do have that underlying right and a fairly strong claim, then we would generally advise them not to agree to the waiver that's been proposed by the employer. I guess the sort of key reason behind that is if the employer is sort of acknowledging that there is an EOT, then the likelihood is that sort of later on in the projects, as part of any final account discussions, or if the matter was to move to arbitration, the contractor is probably going to be awarded its EOT in any event. So sort of on balance, that it's likely that they would get their EOT in any event. So there's not sort of strictly a need to waive their right to claim their costs in addition.
Yeah, thanks very much for that, Greg. Paul, Simon, would you have any thoughts on dealing with scenarios like this in practice?
I'll go on, Simon, after you.
I think it's quite tricky, because I can understand how a contractor may desperately want an extension of time. And then if employer is saying, well, I'll give you the time, but you must agree not to have the money, that is obviously very tempting because of the deduction of delay damages or the risk of delay damages. But of course, commercially, if the basis for the extension of time is that it carries either cost or cost plus profit, that's a substantial discount that the contractor is being asked to give. And then I think it becomes a commercial issue as to whether the contractor is prepared to do that deal. I don't think there's very much, from a legal point of view that one can really add to that, other than I think the contractor in doing that deal would want to be very clear on what the terms of that deal were, because you would want to, as a contractor, say, okay, for extensions of time up to May, I will just have the time and no money. But thereafter, I want to reserve my right to claim what I'm entitled to. So I think deals like that, if they're going to be entered into, that's a matter for clients, and it makes perfect sense in many scenarios. But you would always want to ring fence it to protect your rights to come back later for something different. You obviously can't reopen a deal, but you wouldn't want the deal to be an ongoing acceptance of a position.
I would agree entirely with Simon. It's going to be commercial if you're going to waive your contractual right. And I advise clients, if they're starting to get into a situation where they think they're going to go to arbitration, the claims are sticky, the employer's being very obstructive or whatever, that each claim should be a business case, just as if you were opening an office somewhere, and you've got to look at what you expect to gain, how much it's going to cost you to get to where you are. I mean, I think we've probably all been on the respondent side where it's come to a cost hearing where perhaps the claimant has spent more in legal fees and expert fees than they've actually gained. So somebody didn't do the business plan very well for that case. But it may be that this hypothetical scenario of a drop hands deal, we used to call it in the old days, extension of time but no money, it actually, if you did the business case, might be quite a good commercial outcome, rather than risk a lot of fees for the likes of Simon, Greg, and myself, for an outcome which is perhaps not quite so certain. But if I can hold the screen for, go on. Sorry, no, go carry on with your point.
No, you carry on, and I'll come back.
No, mine was completely different. I was going on a different topic there, actually.
Oh, okay. Sorry, I was just going. Well, shall I just quickly make the point? I was just picking up on what Simon said about if you are agreeing to waive the costs up to a certain point in time, but you are looking to ensure, well, you're looking to leave the option open of claiming the costs after a particular date. One thing that's obviously very important is ensuring that the wording of that agreement is crystal clear, that entitlement remains open post a certain date and for a particular, or at least that the agreement sets out clearly that the claims up to that date and time fall within a certain category, and those are sort of closed off, but everything else is kind of fair game going forward. Because it's quite often the case we find that we'll look at sort of maybe a settlement agreement that's been entered into during the project, and just that sort of provision just is not clear, and there's always scope for the employer to argue that all costs have been waived, rather than just the particular category of costs that informed the U&T entitlement. Sorry, Paul.
No. I was just going to, as an observation, if you like, and perhaps a question after the observation. Looking at your tick sheets, if I can call that, where some clauses give rise to cost and some clauses give rise to cost plus profit. I come from a contracting background, and my philosophy has always been that every ounce of turnover deserves a contribution to overhead and profit. I just wondered if anyone knew the logic within FIDIC for denying profit on certain clause for which the employer takes the risk.
I think Simon may have thoughts on this. But I think with certain clauses, the profit is denied where it's an event that in most instances won't have been caused by the employer. So for example, profit isn't, that you can't claim profit in circumstances where there's been a delay because of a change of law, for example. And I guess the sort of logic there is that, well, why should the employer be penalised for something that's out with its control? So I guess COVID is the example. COVID, there was a number of claims, the basis to a number of COVID claims was change in legislation because the laws of the country changed, which meant that there would be issues in terms of restrictions over labour or health and safety requirements on site. And in those circumstances, the contractor could claim that COT and costs, but not profit. And in one view, that's sort of fair because the employer didn't cause these, didn't cause COVID or the circumstances that have led to the delays on the project. Whereas take site access, for example, profit can be claimed. And if site access has been delayed because of the employer, then that would give rise to, well, a fair outcome, arguably, is that the employer was to blame here, so the contractor should also claim its profit.
Yeah, I mean, I agree with that, Greg. I also agree with Paul that the thinking is not entirely easy to fathom. But I've always thought the differentiation between where you get time only and where you get cost and where you get cost plus profit, the distinction is those areas where you get money cost are, unforeseeable physical conditions, fossils, suspensions, adjustments to legislation, that there's no real fault, if you like, on the part of the employer. It's just something that's happened. Whereas the sort of delays to drawings or instructions, right of access setting out, interference with tests on completion is a good one, and and then the contractor's entitlement to suspend work, you know, all of those things imply something which is not necessarily even the employer's fault, but effectively it's something within the employer's control to avoid. So I've always seen it like that. But Paul, I think you're right that it is a little bit hit and miss, because everything that is a delay which carries money, it hits the bottom line and demonstrates itself in loss of profit.
Yeah, you could argue that if the change in law, putting COVID to one side, because I think that's an exception to everything, but if the change of law was known at the base date, then the impacts of that change of law, additional social costs or whatever, would be in the tender, which would carry profit.
Yeah.
If the unforeseeable physical conditions were known at the time of the tender and the piles went 3 meters deeper, then that would have been a work item which would have covered profit. As you say, it's hit and miss, and I must try and find Chris Sibbald or someone at a conference, whatever, and ask him. But what he thinks was the rationale. Well, actually, I've got one other point of perhaps a little bit of guidance for people. Greg mentioned force majeure events and the frequency and the location. Within the guidebook, the FIDIC guidebook, the Rainbow Book for the 1999 suite, there is a section on interpretation of frequency of such events relating to the period of the construction. So if an event happened, I think it's sort of once every 10 years, but you had a contract period of 10 years, then you might expect it. If it was once every 10 years, you had a contract period of 10 months, then it perhaps would be unlikely that you would be hit by that event. If we were talking about hurricanes, cyclones, and the like. People don't read the Rainbow Book enough, I don't think.
Thanks everyone for sharing your thoughts on this question. I think it's something that generally comes up quite a bit in practice. We are now again set to break for 10 minutes, after which Paul will take us through how to prepare claims, which is a very interesting topic and our final one for the night. Welcome back, everyone. We are now at our last presentation for the evening with Paul, who's going to tell us about preparing contractor claims and what goes into that and the considerations that must be kept in mind. Paul, would you please tell us what goes into preparing claims?
First of all, thank you for inviting me to speak. Thank you to Simon and Greg for those excellent presentations. I think we have a very good background. I'll try and share my screen now. Let's see if it works. Is that working for everybody?
Yeah, that's perfect. Very clear.
Let's get it to the slideshow there. If I may, before I start, just one observation or memory, if you like, in respect to Simon's presentation. I was lucky enough to be in Paris, I think it was 2003, when there was the inaugural, I believe, FIDIC users conference. And it was quite enlightening. It was the packed house for certain. And many of the FIDIC drafting committee, the likes of Chris Sibbald, were on the platform being quizzed for 2 or 3 days. And I think this is the first time that FIDIC had what was being classed as a fatal notice in one of its contracts. And there was a lot of criticism. And I remember Chris Sibbald standing up and said, well, it's quite unfair to have all this criticism, because if you look at the FIDIC contract in its whole contents, then you see the word awareness is quite reasonable. The contractor shall be aware within so many days, 28 days. Because if the contractor is, and I think the words were used, professional, then the contractor will be reviewing its program. It will be reviewing its program quite often and will be updating its program when it no longer reflects reality. And the second point was that the contractor would be making monthly reports, probably at a period of 28 days or so. And again, the contractor will be reviewing every aspect of the project. And if you look at clause 421, which I'm sure that the previous sessions did look at 421, then you'll see that the contractor has to review in great detail its operations. So they said, well, put all that together. And if a contractor doesn't know that he's got a potential claim within 28 days, then maybe the contractor is just not very professional. And I think the words used were, maybe that contractor doesn't deserve a claim at all, which is perhaps an engineer's view, as many of the drafters were engineers. But that was just a side event, and I hope it was of interest to somebody anyway. Okay, Simon and Greg have laid the foundations for me to be the quantity surveyor on the panel, one barrister, one lawyer, and now a quantity surveyor. And I'm going to look at claims and claims preparation. It is a great topic on its own, and one that I can talk, and many others can talk for days on the topic. But let's see what we can get done in the time available. So, what am I calling a claim? For the purpose of today, I will just recap a little bit on what Simon has said, but just pick out two little sentences. Any extension of the time for completion and any additional payment. And I will dwell on those two facets. I'm not going to be talking about variations. Greg picked up on variations. I'm going to be talking for a request for time and or money entitlements. It could be relative to one event. It could be relative to a series of events, but it's not going to be in detail about variations. Now, I like to think of any claim that we're talking about that it's got certain hurdles to overcome. So I have my picture of a little hurdle race, and I've said there at the top, it's a 3-hurdle race, and if you fall at one hurdle, you don't go on to the next one, and you're out of the race. So Simon very eloquently spoke about notices and perhaps ways to wriggle around the notice clause. But if it's a notice in the contract, let's assume that you've got to get over that hurdle. Or if it's a notice of some sort that's necessary at law, you've got to comply with the civil code of the UAE or some other civil code somewhere, that you've got over that hurdle. So then we go on to the, should we say, the more meaty parts of the claim. We go on to the fact-based demonstration of the events, the merits of the claim, as I like to call it. And that will depend, as we'll see later on a lot of facts being gathered, and Simon mentioned a lot of facts being gathered and put into a comprehensive bundle for someone to review. And if you get over that hurdle, you've got to persuade somebody that those merits are worthwhile. I actually was involved in an arbitration which went on for 4 years, and it was going to be in 4 parts, 3 parts, sorry, anyway, because the chair was a sitting judge. So we had to have the arbitration hearings when the courts were in recess. So the first hearing was going to be law entitlements, contract entitlements. The second hearing was going to be on the merits, and there were going to be interim awards after each of those two before we went on to the quantification hearing. So then finally, the quantification hearing, if you like, establishing the actual effect of the events, the cause and effect. We've got all the events, we've got all the merits, and we've detailed what actually happened. And now we've got to say, well, what was the effect in terms of time and or cost, maybe profit, maybe not profit. So this is my 3-hurdle race. And I always try to think of claims in this fashion. Now, I think everyone on this webinar, and certainly the 3 people that I'm sharing the platform with, if you like, at the moment, will have heard the phrase records, records, records. Why do we need records? Stepping into the legal world, I understand the phrase, he who asserts must prove. You can't just say, I'm entitled to it because I think I'm a nice chap and I think actually a good solution to what's going on. You've got to establish things, you've got to assert things, and you've got to prove what actually went on. You may be proving your case to a very different audience. It sometimes might be the employer. Sometimes we get FIDIC contracts where they've been amended, so the engineer has his wings clipped, and the engineer can't issue decisions, determinations without consulting the employer. So you may be looking at persuading the employer. You may be looking at just being hopefully persuading just the engineer. It may be in certain circumstances, if you're a subcontractor under a FIDIC book or any other book, that you've got to persuade the main contractor. Or you may have to persuade, now the thing's covering my slides. Let me see if I can move the speakers parts of it. A dispute adjudication board. If we go on within this form of contract, we have a dispute adjudication board. The newer contracts have a dispute avoidance and adjudication board. But you may have to persuade those people, whoever they may be, lawyers or quantity surveyors or engineers, at the phase of avoidance or at the phase of adjudication, that you are good. So you need the records to support your case then. Or if you cannot succeed without going to formal dispute resolution, it may be an arbitration tribunal or a court. And I want you to consider that the records that you can keep if you're a contractor are the sword which claims are prosecuted, and they are also the shield which claims are defended. Other people will keep records, different records perhaps from yours, but the records will be kept by everybody. And I would like to think that excellent records may reduce the likelihood of a dispute. A phrase that I often use to people is, you're putting the other side in a position where they cannot afford to say no to a claim. It's the reverse, perhaps, of the business case I mentioned in that little segue just then. The engineer, the employer receives your claim and says, wow, this is a bit good. What's going to happen, Mr. Engineer, if I say no to this? Well, you're going to go to a very expensive arbitration, perhaps, and it looks like we're going to lose. So please be sensible and let's talk around the table or whatever, if it might be at a 3-5 determination part, where the engineer invites the contractor and the employer to get around the table and talk. Now, a very famous quotation. It's in the book of Max Abrahamson. When I had my 4-year arbitration, I did a lot of downtime. It was in a foreign country and I wasn't allowed to go home. And I think I read this book cover to cover. It was a long time ago, but it still has a lot of very, very good things in it. So Max said, in order to demonstrate the entitlement must be a story, the merit supported by, and he said, party to a dispute, particularly if there's an arbitration, will learn 3 lessons often too late. The importance of records, the importance of records, and the importance of records. Now that I will repeat myself many times, that records are so fundamental to a properly produced and successful claim, and possibly defense of a claim. Now, drifting back into FIDIC, as we are on a FIDIC roadshow, there are certain obligations within the FIDIC contracts for records to be kept. Again, if you look at the progress reports under 421, the progress reports are very detailed. Forgive me while I pick up a FIDIC contract. And the contractor has to provide all sorts of things within the progress reports. And if you're a contractor, you've got to have obviously the charts and detailed descriptions of progress, including each stage of design of the contractor's documents on Reader Yellow Book, procurement, manufacturer, etc., etc. Photographs showing the status of the manufacturing progress on the site. The manufacture of each item of plant and materials, the name of the manufacturer, the manufacturer's location, percentage progress. And it goes on, commencement of manufacturer, contractor's inspections, tests, and shipment and arrival at site. These are fundamental records in the procurement process that can be a sword and can be a shield. The shield in that the engineer later on may say, well, in your original program, your clause 8.3 program, which you're going to be updating all the while, you said you were going to procure that steam turbine, that set of pumps, or whatever it may be, at certain dates. Now, later on, when we get into the site, you're telling me that my delayed access to a certain area of the site has caused you problems. You've made an extension to the time for completion request with costs because of that access problem. But I know that you actually are not ready to proceed because those pumps will not be on site until much, much later than you said. And actually, the delay will not be my lack of access, but it might be your pumps being late. So there is going to be a counter argument, the shield for having records. And going on down into the depths of 421, the details described as in subclause 610. This is the records of contractors' personnel and equipment. Again, when the original programs were put together under 8.3, there's a report that goes with them. And those reports will have resources. The contractor will tell the engineer at the outset what resources will be needed at any one stage of the project. So when the contractor again makes a claim, and the engineer can turn to him and say, well, hold on, the progress of your works is different, not because of my delays, it's perhaps because of your lack of resources. You told us what resources you were going to have, but you haven't had them, and you've given me the records. You provided me with a shield to say you're not proceeding with due diligence. But on the other hand, the records of personnel may show thickening of resources, it may show some form of acceleration or mitigation of delay, and so on. Anyway, and then obviously the final obligation to keep records is within clause 20.1 itself, where the contractor has the duty to keep records. The contractor shall keep contemporary records as may be necessary to substantiate any claim, either on the site or at another location acceptable to the engineer. And the engineer may ask the contractor to keep other specific records. The engineer may say, I want you to keep records of this because I don't think the records that you're showing me will demonstrate the entitlement that you say you're entitled to. As a tip for you contractors out there, if I get into a clause 20.1 situation, I tell the engineer what records I'm keeping. And I ask the engineer, do you think this will be sufficient for you to make your decisions under 3.5 following the submission of my claim? It would be very difficult for an engineer perhaps to deny a claim on the basis of insufficient records if he's been given the chance to say what records he wants and he's turned that opportunity away. What sort of records we expect to keep? I will not bore you with the whole list that I put down here, but I will say this is typical. Obviously, we're going to have the program. If we're talking of time extensions, the program is going to be key. I often say to people that the most important person on a project for me is the scheduler, the programmer. He is the early warning, she is the early warning on that site. The updating of a program will show when things are going to slip. It may show things that are slipping that are the contractor's risk area. If that happens, I tell my contracting clients to put it right very quickly. Expend a little bit of money to avoid a problem later on of concurrency of delay or whatever it may be. If that updating the program shows it's an employer's problem, then I tell them to shout. As Simon said, shout every time there's an opportunity for a notice. You've got to put that notice down as quickly as possible. It gives the employer, as we've said, the chance to change his mind. It gets that mark in the sand of there will be a claim coming if we don't do something. Just going back, I think, to the Gibraltar Orascom case, I think, if I remember rightly, and Simon, please jump in, I think the defense that the engineer used was that the instruction, I think it was instruction to widen the carriageway. And the instruction, I think, was issued sometime in June. And the contractor did not respond because at that time, the works were not on the critical path. Later on, those works became on the critical path, and that I think was much later, but it was only, as the judge said, they could see they were on the critical path, but there was still no obligation to give the notice. But when it was on the critical path and caused delay, that the judge said, okay, that's fine. It was a little bit of a, some people say, a softening of that clause. And I think that softening perhaps has moved into the thinking within the 2017 edition, which personally, I prefer the black and white, or black, white, and a little bit of grey that's in the 1999. I do not like the in and out situation of 2017. I think it's very complex, and I like contractors to have some certainty of where they're going. But I've digressed, excuse me. So, typical records. I emphasize the program. I emphasize things that will provide clarity to anyone looking at your claim. Progress photographs that must be with dates taken. Photographs, videos, drone footage. There's lots of people out there that market time-lapse photography. And I've seen some wonderful examples of this. There were 2 towers built in London, which were supposed to rise on a slip-form concrete out of the ground in parallel. And the time-lapse photography shows one tower creeping ahead of the other one, then the other one catching up. And it's an excellent demonstration of causes of delay, if you can then link the effect or the effects of delay, if you have the right causes. But again, I will not read all of these. Obviously, things that they are definitely in the employer's risk area, drawings, if it's a red book, issues of drawings, all the amendments, drawing registers, and so on. And don't forget, very often, if you're a main contractor, a lot of the claim items that you will have are those that are put forward by your subcontractors. So there you must put your subcontractors under the same obligations as you are to keep records with the labor and plant returns, schedules of material deliveries, and so on. And again, don't forget that if you are claiming, you will probably have some idea to claim head office staff involvement. We'll come on to head office overheads in a minute, but I see that there may be an interim thing between head office overheads, obviously the people that are allocated to the project on site, but you may get certain categories of staff that are allocated to the project, but in the head office. The design staff, for instance. And all too often when we're preparing claims, we see that these people do not keep adequate records of their time. Their design office, they just design, but they don't have a cost center perhaps for the project. They don't have a separate item on their timesheets for when they're dealing with a variation or change, omission, or whatever it might be. So these are the sort of records that when I'm preparing a claim that I look for when I'm expert witness. These are the things that an expert witness will be looking for, time or money, to progress the claim or the opinion regarding the claim. And as I've said, the other side, the employer, the engineer, they will have their own records. It may not be the same records that you keep. They may be keeping different diary notes, but they will have their records, the intentions that the contractor had, the revised intentions under subclause 8.3 with the program, all the records you have. So they may be in the situation, to be the reverse of my putting other people in the position where they can't afford to say no, that they have every confidence to say no. And then it's the contractor that has to think about the business case. Do I go ahead with my claim? How much am I going to get? How much is it going to cost me if we go beyond settlement of the dispute at site level? Time claims. What are we asking for? A time claim is a demonstration that the contractor is unable to achieve contractual completion within the time for completion or the duration that is specified because of an occurrence of an excusable, compensatable delay. If we go back to the wording in clause 20.1, it is an extension to the time for completion. To gain an extension for the time for completion, the delay must be on the critical path. There will be other delays that occur on a project that will not affect the critical path, that may be within the risk area of the employer, but they will probably cause disruption. For the time for completion to be extended, the delay must be on the critical path. It's normal for expert witnesses, claims consultants, or whatever, to prepare a time extension claim. Methods that are used normally, and I recommend, should follow industry guidelines. The most used standards are these two. Being an SCL counsellor, I would obviously say the SCL is the most succinct and most thought out document. I was around on the SCL Council when the 2017 version was put together, chaired by Kim Rosenberg in Dubai, and it was an excellent piece of work. The Americans have their own equivalents, and I actually sat on an SCL conference where we compared the two. Marianne Ramey was on one side, Kim Rosenberg and I don't think who the other one was on the other side. And Marianne Ramey was on the SCL, and passed away sadly, a guy from Ancora and another guy from the States were both AACE members. They are comparable. The SCL has 6 commonly used methods. The Americans expand that 6 into many, many more by subvariants of these. But basically, you can take these 6 methods and look to see which is the best for you as a contractor, which is the best for you compared with the records that you have, whether you have an obligation perhaps to make a prospective claim, or whether you're going to do it contemporaneously. I'm saying that I think that those two would be what FIDIC would require, or whether if you get to the stage of arbitration, then maybe you're looking backwards in making a retrospective claim. And you can look at the chart and see that the analysis type is cause and then effect, cause and effect, effect then cause, effect then cause, effect then cause, cause and effect. There are options for whichever is going to suit you. Maybe I'll ask Simon at the end of this session, which is the most favoured method by the courts in England, because I think over the years it has perhaps changed. And I think some methods, such as the collapse as built, are not favoured at all. And in fact, I think they've been recently criticised. But if you, I'll ask Simon at the end of that, unless, yeah, we'll do it at the end. So whatever you've got to do, you've got to prove that critical path delay. And these are the methods which I would recommend that you use. Okay, moving swiftly on to money claims. Craig discussed cost. Cost in FIDIC is a defined term. Cost means all expenditure reasonably incurred or to be incurred by the contractor, whether on or off-site, including overheads and similar charges, but does not include profit. So within your contractor's claim, you can put claims in there for overheads, whether they be off-site overheads allocated, as I've just said, or off-sites in the overhead and profit type regime of the formula which we'll look at in a minute. I often find, and I had a situation where a client came to me and said, we were very disappointed. We took a claim to a DAB. The DAB awarded us a full extension of time, but compromised us on costs quite considerably. And they said, would you come and talk to me about what went wrong with my cost claim? And it wasn't a FIDIC contract, but it virtually copied the clauses. And what they had done is they ignored the word cost, and they had priced everything in accordance with a schedule of rates that was in the contract, which were for variations. These were selling rates, and the DAB took offence of that. They said the contract says cost. The contract does not recognise, therefore, your selling rates, and therefore the DAB knocked back those rates to something it felt was more akin to costs. So please, when you're preparing your claims, do what the FIDIC contracts say and look at what the costs are, not what you think the selling rates are, even if they're in the contract as a schedule of rates for variation. And as Greg said, profit to your claim may be added under certain clauses. I'm going to look quickly at prolongation costs. Again, prolongation costs, a definition for you. Time-related costs incurred as a result of a delay to completion for which the employer is culpable. There's the elements there, the employer is culpable and it's time-related. Again, I sometimes have people a little bit confused by when the extension of time is granted, which is obviously to the pushing the date for completion back, as to why don't we have those costs as our claim. So I have to get out this little chart for them and say, you have a delay that incurs sometime in the project, and therefore your claim should recognize the resources at that point of the project. It may be that your delay occurs when, if you're constructing a power plant, a major power plant, you may have 2, 3, 4, 5,000 people on site, where if the delay occurred when you were commissioning that power plant, you'd maybe only have a few hundred people at site. So it's important that your delay analysis pinpoints exactly when the delays happen, and that your cost people, your quantity surveyors or whoever, recognize those periods precisely, and that you have the records for those periods so that you can put together your proper cost claim compared to when the delay happened on no other period. So understand the period relative to costs and value the actually incurred costs by the contractor during the extended period. So prolongation costs. This is quite simple. What elements have been affected? We're looking at the non-work related items. For example, the project manager may be on site an extra 10 weeks. The engineers may be on site an extra 10 weeks. The administrators, the quantity surveyors, the schedulers, and so on. They may be on site for an extra 10 weeks, as demonstrated by the delay analysis. The site establishment, everything that people often call preliminaries, the site offices, the storage, the computers, and so on. And then there may be other time-related items, such as bonds, insurances, that have to be extended because of the obligation to keep a bond or to keep the insurances throughout the whole contract period. Then there's the other part, plant and equipment, the items that service the work, rather than the items that are included perhaps within the work-related items. Those may be prolonged and form part of a disruption claim. For instance, your excavators in digging trenches, the trenches may have taken longer to dig for some reason. You may have a disruption claim for that. And I'm not going to talk about disruption claims today in any great detail. These are the items that service the work and are spread amongst everything. I think it's quite easy to say that I can see from this picture that the tower cranes will be perhaps looking at the steel work, then they'll move on to the cladding, then in the interim, they may be helping to pour the concrete or lifting the reinforcement or whatever. So cranes, forklifts, scaffolding, they service the work rather than being purely related to one work item, that if you had a bill of quantities, you would price that item of plant within that bill of quantity item. Head office overheads. We are talking about, when I think of head office overheads, putting aside those staff like the drawing office, the design office or whatever, we're talking about the actual overhead of the office, the building, the rents, the rate, the finance department, the marketing department, the senior managers. If you can imagine that every project has a contribution to this head office overhead. And the simple way to imagine that is a contractor only has one project. That project is going to take 1 year, and its head office overhead necessity is £1 million per year. That will fund the head office overhead, including perhaps some research and design, whatever. So the 1 million is divided by 365 days, and that is the contribution that the project expects to deliver to that company. If that project is delayed by 1 year, then you have 2 years for the same amount of recovery. So the contribution to the head office overhead is halved. So we've got to try and recover that contribution by some way. And the way that is most simple is formulas, which I'll go on to the next slide. But if you have a formula, but you can find items that may be classed as specific head office overheads, such as bonds and insurances, deduct those out from the formula total, because they can be specifically demonstrated by records, invoices, and whatever. The formulas will not be able to be demonstrated in the same manner. I'm not going to go into all the formula and what the differences are, but there are numerous. Hudson is the daddy of them all, and probably the most simple of them all. There's Etchley. Etchley has variants as well. Emden, Manshall, Carteret, Allegheny formulas. They all have their own peculiarities, and if they are applied correctly, will come up with different answers. I think it's still there on the SCL website. There's a spreadsheet which I think Jeremy Winter put together, comparing Hudson, Simple Etchley, and Emden. And you can put in certain facts and it will give you an answer for those facts that you put in. And it does come up with 3 different answers. Disruption costs. As I say, a brief look at disruption costs. Again, I like to give people a definition. These are the costs incurred as a result of a disturbance, a hindrance or interruption to the contractor's normal working methods, resulting in lower efficiency. The normal working methods, the contractor will often say, these are the methods that I intended to use. And most claims will start with the intention of the contract. Proving disruption may come with different methods, which might relate to the measured mile, for instance, which is showing an uninterrupted, undisturbed passage of work, which sets a measured mile basis to compare with a disrupted passage of work. So disruption costs, another definition if you like. The time taken to carry out a task is longer. The income remains the same. The costs increase, and this equates to a loss or a possible claim if you can have the cause and effect going back to the employer. Looking at it in another graphical form, a disruption event occurs, say a lack of complete access to an area. Contractors or subcontractors want to have the whole field available to them so they can plan or carry out the work as they planned. It may be that only half the field was there, so working was bunched. Trenches could not be dug from A to Z. It had to be stop, start, or whatever. So the work then has to be postponed, and a critical delay has also occurred in this instance. So we have the disruption because we have more costs to carry out the same work. Again, looking at the SCL disruption delay and protocol, it lists various methods of carrying out disruption claims. Project specific, like the measured mile I've just alluded to, earned value, program analysis, work or trade sampling, systems dynamic, project comparison studies, which are not project specific, industry studies. There have been various studies done over the years. I think some in the UK, predominantly in North America, where people look at factors like working at at height, I'm going to say altitude, working at height, working in hot weather, cold weather, bunching works together and so on. And then there's cost-based methods, estimated incurred labor, estimated versus used labor, excuse me. I'm not going to give you an example of all of them, but I will share with you this quite nice chart, which is put together by a gentleman called Ibbs. And basically, it is a comparison of the results, the level of record keeping, the contemporaneous product documentation, and the effort to make the claim. The result being the better the records and the more effort to prepare, subject, say, a measured mile, gives you the higher certainty of reward. If you were the contractor that didn't keep records, wanted a low-cost claim prepared, possibly as a, should I call it a bluff to get somebody to the negotiating table. But if you went to a tribunal, you would expect a low expectation of reward. An example of that would be the total cost claim, where the only records you may have is the total cost for the job, and you have your expectation of recovery, and basically you compare the two. What does a claim look like? Well, I have my own templates for claims, and I think these are fairly industry standard. It must be logical. The claim must demonstrate the cause. It must demonstrate that cause is not in the contractor's risk area. You must go on then to the effect, the cause and effect, the logical causal link, the time delay or cost or damages or loss and expense, whichever phrase you want to use it. Then we come back to the justification, the story, the merits, and then the evaluation, how much time, and of course that evaluation of time or money has got to be substantiated by a delay analysis or supported calculations of cost. I like to think of a claim that I would prepare would be concise, precise, easy to read, understandable, factual, if my client allows me to do it, if there's a factual basis, and believable. Whoever is going to read the claim must, I won't use the word enjoy reading the claim, because they probably won't enjoy reading the claim, but it will not put them to sleep. And again, a typical format for a claim, a typical template, however short or long the claim may be. Claims do not have to be war and peace. They do not have to be long documents. If you can demonstrate things in short fashion, please do it. Don't overwrite things, but it should have some sort of introduction, an executive summary, so people can know exactly what you're looking for, the contractual terms you rely upon, or the terms at law, the first hurdle. Then what are we doing most times? We're comparing planned and actual sequence of events. We're then looking at the events and their effects on the sequence of construction, program, and then the evaluation of costs. So we've got the cause and the effect running through this all the time. Again, perhaps the war and peace version, or maybe not. I like to see paragraphs numbered, and I think that the days of having paragraphs with sub-paragraphs or whatever are gone. I think Simon agrees with me on this, because one set of numbers from A to B, one to wherever, it's a lot easier. It's a lot easier if you have to get to an arbitration tribunal. The tribunal have ease of reading paragraph 432 to 435, not paragraph 4.1.3, subparagraph, whatever. Short paragraphs that deal with one statement. Don't overcomplicate things. The so what test. Every time you write a paragraph, say to yourself, what does that add to my situation? Does that support my claim? So what? It may be that you think, I'll take that paragraph out, or I'll take 2 sentences out of that paragraph. Use footnotes to keep paragraphs short. Rather than people citing a whole reference to a document, just put a footnote and cite the document. And use appendices to keep the written word short. I've put a note in there, which one arbitrator once said to me, people give me claims and they make it a one big fat lever arch file, which includes the written word and the appendices. When I'm sitting in my hotel room or lying on my bed at night, I like to have one folder with the appendices and one folder with the written word. So when I get a reference to an appendix, I can then look without going from flipping all the documents over and losing the pages. I can have the two open at the same time. And I learned from that, and that is the way I do it, no matter how short or long the claims are. And I think I will stop there. It is a subject, if I can say, I can talk forever, and I would not bore you any longer. So thank you for listening. Good luck with achieving whatever your goal may be, whether it be defending a claim or prosecuting a claim. And I'll stop sharing and hand you back if I can get to the right screen to stop sharing. Stop share. There we go. Thank you.
Thanks very much, Paul. I think that was very interesting, and I suppose one of the key takeaways for me was make your claims interesting, make them interesting to read, and I think that's a nice thought. Right, I think we are slightly over time and in a bit of critical delay, but there is one question, and I would appreciate if you could jump in briefly, and I think it's to do with what are the issues that arise and what are the considerations in trying to prepare total cost claims, global costs? Yeah, I think maybe Paul, you could go on with the practical stuff, and Greg, Simon, legal issues that might arise from such claims.
I think for me is I think that nice little chart that Mr. Ibbs put together, a total cost claim is a claim of last resort. I've seen total cost claims. I was involved in a major arbitration quite recently where the contractor obviously had good reason to make claims, but they just did not keep any records. And so they tried to produce claims in sections. This is the concreting, this is the reinforcement, and so on. But when you added all these sections together, because it was a civil engineer package contract on a power plant, all it was a total cost claim. And their expert witness had very little to go on. They suffered in cross-examination, both witnesses of fact and the expert, as to why they didn't keep claims, why did they keep records, if they were aware of the claim. And they just had to shrug their shoulders. So it is a claim of last resort. It's a sympathy claim for me. And as I said, take out whatever you can, whether it be a variation or anything, if you can justify that claim and have some realism about it. Maybe make adjustments for what was never going to be a perfect tender or your own inadequacies at site.
Right. I think that's, Simon, Greg, maybe we start with Simon. Do you see any legal issues or issues to do with principle in making such claims and how to navigate those?
Yeah, I mean, a lot of the more difficult work that people like me and Paul and Greg are dealing with day in, day out, they are essentially all dances around one issue, which is causation. Because if you take causation out of construction, it's all quite straightforward, really. Once you put causation and the need to prove some sort of causation back in, it all becomes quite complicated. So this is all about causation. And I think the starting point, if you put your sort of self in the position of the employer, and you've got a contractor who's saying, well, I know I've spent $20 million more than I plan to spend, and therefore I want that money from you, the employer. The employer's going to say, well, thank you very much for that claim, but there are all sorts of reasons why you might have lost that money. Like you were always going to suffer a loss. You put your tender together badly. your resources weren't adequate, it was a design and build and you didn't get the design right, you had to do your procurement and you didn't do your procurement right. So from an employer's point of view, and I think this builds on a point that Paul's made, which is that claims are fundamentally intended to persuade an audience. So it is worthwhile starting from the position where you're a contractor thinking about what your employer is going to say. Your employer is going to come up with all those points. And those points are not necessarily bad points. So you do have to think about causation. And the last thing that Paul just said was very much one of the things I was going to mention, which is, I think if you have got $20 million and you're just not sure how the loss arose, what you need to start with, I think, is, right, well, go for the low-hanging fruit. Your variations claims, your claims under the contract, your delay-related, extension of time-related money, your time-related money. And what you're then able to do, if we're imagining the 20 million, which is some form of overall loss, is that actually you're never going to solve the problem of global claims, but what you can do is shrink the global claim issue so that you've had all of the easier, potentially easier contractual money out of the thing. And so then you've got a rump of what might, let's supposing it's 5 or 10 million, which really is very difficult. That will usually be blue collar resource because it will be disruption. Your white collar resource is in your time claim. So it's blue collar resource. And then I think all you can do is do your best to chop it up. So try to do, if it's power station and there are 5 units, you might look at it on a unit basis, or you might look at it on a calendar basis where you do CVR, cost value reconciliation. You've got your costs for a month, you've got the value, the money that you're earning under the contract, and you've got this delta, the difference, and you look at it month by month, you look at it area by area, but frankly, you're still possibly looking at 20, 30, 40 events which may have caused that area loss within a month. But you try to boil it down and effectively present to a tribunal a series of events that might give you entitlement, like breaches or access issues. You've then got a monthly loss within an area and it's chopped up. And then I think it is slightly easier to invite the tribunal to infer that the loss seen in that particular area, that part of the power station in that particular month, is caused by the events in that particular area in that particular month. And it's an inference. It's not causation as such, although, you know, it's a philosophical question ultimately as to the difference between causation and an inference of a relationship. The most I think you can do in the more difficult cases is try to create mini situations where you can invite the tribunal to infer a causal relationship. And that is best done on the evidence. It's not straightforward. There's no one size fits all. I don't think there's a magic formula, but I do think attempts to deglobalize things and chop things up can make that inference more palatable.
Thanks, Simon. I think that was very interesting. Break it up and, really, play to your audience. I think that was interesting. It's ultimately something that you need to consider what will persuade your audience. Greg, would you care to weigh in?
Yeah, I guess just sort of one final thought. And yeah, I totally agree with everything that Simon said there in terms of breaking the claim down as much as possible. It's more just sort of my part of the world here in the Middle East and in Dubai. The forum is always a sort of an interesting issue in terms of where you get to sort of a formal dispute and what's the best forum for particular types of claims. And in circumstances where maybe a contractor has the option of arbitration or instead the local courts, but they really only have a global claim, then then sometimes the local courts can get a bit more success, just on the basis that they're much more of a sort of high level forum where there isn't so much of a focus, or at least less of a focus on issues like causation. It's in a lot of instances a kind of high level investigation that takes place. And in certain circumstances, kind of going back to the point that Paul made, that a global claim can be a claim, a sort of sympathy claim, you can sometimes get a bit more traction in the local courts than you do in arbitration, just because it's not such a, I guess, as a forensic forum. So really, it's just that as a kind of final point from me on those types of claims.
Thanks. That's
Jatan, one thing I was going to briefly just touch upon,
Please.
very, very briefly, and it was Paul's points about different delay techniques. I think that one is a very interesting one, and it's probably a talk all on its own. But you know, that there is perhaps a distinction to be drawn between delay techniques that you have to do while you're on the project as a contractor. You're midway through the job. Time impact makes a lot of sense during the course of the job, but once the job's done and the project finished 2 years ago, my sort of sense, and I don't know, Paul and Greg, what you think, it's very hard in arbitration to sell a time impact analysis which is projecting into the future when the job's done and dusted, and you know what's happened because you can look back and you can do an as planned versus as built. So I think the direction of travel for projects that are done and dusted is very much as planned versus as built. Within that world, however, lots of nuances, because you can have as planned versus as built time slice, where you use a program, if you've got a very good, strong baseline, which can then be updated every month with contemporaneous records and reporting. Time slice can make a lot of sense, and it can seem very scientific and reliable. If you haven't got a strong baseline and you haven't got really the facility to do time slices, but you can do what's sometimes called as planned versus as built in Windows, where you just look at the records month by month on a granular basis, and you see what's driving progress in terms of what's the longest kind of remaining duration within a window. But those sorts of as planned versus as built techniques, I think in court, certainly in the UK, but frankly, most of my stuff's international arbitration these days. It's an easier sell to an international tribunal that effectively, job's all done, so let's look at something which is retrospective. But Paul, it's a very interesting area, isn't it? It's one we could talk about all day.
It is. Yeah, indeed.
Right. Thanks, everyone, for joining us here. I would like to thank Greg, Simon, and Paul, and of course, most importantly, all our participants that have attended this webinar. The video will be up on the SCL India's YouTube page, so you can keep watching it, tell your friends and colleagues about the series, and we hope that you will join us next month for the next session of the series, for which we will publish details in the next few weeks. Thank you, everyone. Good night.
Thank you.
Thank you, everyone.
Thank you.
Take care.